Good morning, Poonam. Also asked the friends who are not attending the lectures live to share their number with me for the act. And the matter will not end with the act. I will keep on sharing more information. I keep on doing lots of other webinars also. Don't send me number here. Send me on WhatsApp. My number is displayed on the board. Okay. Don't show number here. But this is a public platform. You may not like to display or share your number. So just send it to me. My number is displayed on the board. Okay. So now I think it is time for us to start. Let the other people join over a period of time. Okay. And what we were doing last time, can't see my number. What can I do to have the full-fledged? Maybe the coordinator can do that because I'm not very video options. What are the options available? Should I write it on the chat for you? Number is 961961280. So this is the number on which you have to send your requests. And I don't know how to make this full screen. Nikhar can do that, I think. I'm not able to see how to make it full screen. Can the coordinator do it full screen for me, please? And I'm going on the Word documents that we were having last time. Can you make it full screen for me, please? This is what we were discussing last time, and I'm taking it further to that. We were now about the Section 8 companies. So as far as Section 8 companies are concerned, these are companies which are created for a specific purpose, and what are the purposes? Those are mentioned herein. This may be either promotion of commerce or art or science or religion or charity or education or protection of environment. And in the current scenario, you can also talk about the welfare of the society. So social welfare, it is already mentioned therein. Medical facilities is also there. So for any social activity, charitable activity, you can incorporate a company which will be referred as a Section 8 company under this law. In the old law 1956, that was referred as Section 25 company. Can you hear me properly? Can you hear me properly? For a moment, I'm stopping the sharing just to get you. Yeah, okay, thank you, thank you. Please keep on telling me so that there is no disturbance. Okay. So these are the companies created for this specific purpose, and there are two ways in which these companies can be created. One is a new company itself is incorporated under Section 8, and another is existing company converted to Section 8. Okay. So now I'll have a right to share that in a bigger screen for you. So what I'm telling you that Section 8 companies may be new company or it may be an existing company. So new company will have the objects in the memorandum, and these are somewhere similar, right? Now read clause A with me. What it says: has its object the promotion of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment. Now the list does not end here. Last words or any such other objects, those are very, very important words, because prima facie it should not be taken that Section 8 company can be engaged in only in the activities which are referred here, which are the promotion of art, science, culture, religion, charity, etc., etc. It can be anything as long as it is matching these objects of the society. And not only objects, then further intends to apply the profit, if any, or other income in promoting its objects. Now, common misconception, a very common misconception, that Section 8 company is not a profit-making company. It has to be a profit-making company, otherwise how it will survive? And if it doesn't make a profit, then only way of survival will be more and more donations. That is not the objective. Objective is that if there is any profit in the operations earned by the company, then that profit will not be distributed by way of dividend, and the dividend and the profit will be applied only for promotion of the objects for which company has been formed. It never says company should not carry on business with the objective of making profits. Profit isn't necessarily a part of business. It has to earn a profit, and whatever profit may be, that should not be utilized for distribution by way of dividends. So that is the purpose. And this says further, the central government may issue license here. So without a license, you cannot incorporate a new company. So when you want to make a new company under Section 8, first of all, get the approval of the name, make an application to the regional director, get the license, and then only you can make application for incorporation of the company, right? So there in between, there is a period to make the name available, ensure that the ROC has confirmed the availability of name for incorporation of this company, and then get the license, and the license is issued by the regional director. They mention central government, but majority of the powers of the central government have been delegated under the Companies Act to the regional directors. So this license will be issued by the regional director depending upon what are the objects and what are the contents of articles of association. Because in the article, certain more restrictions are required. Nothing can be paid directly or indirectly to the members of the company, either in the name of salary as well, some other benefit as well. Nothing can be paid to the members of the company. That's why the memorandum and articles are required to be checked. So when you make an application to the regional director, you will have to file the draft memorandum, you will have to file the draft articles, and only then this will be available. Let's move further. Now, under subsection 2 here, see here, the company registered under this section shall enjoy all the privileges and subject to all obligations of limited company. So it is a company. Limited company means liability of the member is always limited, and liability is always toward the company. They cannot, the outsiders cannot directly sue the members for recovery of their dues from the company. So that all the features of the company are available to this company as well, but condition is it cannot distribute any amount of profit by way of dividend. It cannot amend articles as well as memorandum without the permission of the government, because the license has been granted on the basis of existing content of the memorandum and articles. And if you change or amend the memorandum and articles, it is changing the terms and conditions of the license. So that's why even amendment of the memorandum article require approval of the government here. See here, in subsection 4. A company registered under this section shall not alter the provisions of the memorandum or articles except with the previous approval of the central government. So why the previous approval is required? Because getting this license is based on draft memorandum and articles filed with the regional director at the time of making application. So those become terms and conditions for the license. And if you want to change the terms and conditions on the basis of which license has been issued, it will require prior approval of the central government. Okay. Now, subsection 5, this is talking about the conversion of an existing company into a Section 8 company. So, where a company is already there and it is matching the objects which are mentioned in subsection 1, and it is having the articles restriction on prohibition on the distribution of dividend, then that company can also be converted into Section 8 company. Now, what is the advantage of converting into a Section 8 company? Prima facie, the name of this company need not have the word limited or private limited at the end. Number one. So because whenever these words are associated with the name of company, it is treated as if it is carrying on a commercial activity with the object of earning profit only. That is only a presumption. That may not be the correct thing, but this is the social impression created by adding the word limited or private limited in the name of company. So when you have a license under Section 8, these words are not required at the end of the company's name. Number two, lots of exemptions have been granted by the government to Section 8 companies, and the moment the license is given, those exemptions automatically become available. You don't have to apply for those any kind of exemptions separately. Number three, special exemptions can also be given on case-to-case basis if required. So these are three things because of which Section 8 companies are quite common. I have one of my own company, Section 8 company, and the name of the company is called a Social Support Foundation, and that works only for mentally challenged children. So I run that company. Okay. Now moving further. Now central government can revoke the license. Why the revocation of license? If the terms and conditions of the license are violated, then the license can be revoked. But no important decision can be taken unless an opportunity of being heard has been given. And if license is revoked, what will happen? See here in subsection 6, it says the central government may by order revoke the license granted to a company registered under this section or contravene any of the requirement of the section or the conditions subject to which a license is issued, or the affairs of the company are conducted fraudulently or in a manner violative of the objects of the company or prejudicial to public interest. So, license withdrawn, the very first effect will be the name of limited, private limited will get added, plus penalties for violation of the terms and conditions will also become applicable. Okay. So, under subsection 7, further consequences of violation or rather revocation of license. So when a license is revoked under subsection 6, the government may by order satisfy that it is essential in public interest, direct that the company be wound up or amalgamated with another company registered under this. So here you can take a note, very specific note, that a company which is registered under Section 8 cannot be merged or amalgamated with another company which is not a Section 8 company. So amalgamation is possible, merger is possible, but only between two Section 8 companies. Section 8 company cannot be merged or amalgamated with another company which is not a Section 8 company. Okay. So this is further talking about the government can issue a direction for amalgamation of that company with another company, but only after the revocation of license. And if it is winding up, then in case of winding up also, any surplus assets will be transferred to another company which is having the similar objects. You see here. This is very, very important. This will help you in many professional questions. A company registered under this section shall amalgamate. Not only amalgamation, even merger will also come in that. A company registered under this section shall merge or amalgamate. You can add the word therein. Only with another company registered under this section and having similar objects. And this will be a case where prior approval of the central government will always be required for merger or amalgamation. Okay. So that was Section 8, and now coming to Section 9, this is talk about the certificate of registration, or you can say the certificate of incorporation. What is the impact of issue of certificate of incorporation? So the date on which certificate of incorporation is issued by the ROC, a legal entity comes into existence, and that becomes a body corporate. And being a body corporate, it will have all the characteristics. It will have immovable property registered in its own name. It will have its own share capital, and the shares are always movable property, transferable. It will have perpetual succession. So all corporate characteristics will get vested herein. Now, effect of memorandum and article. This you have to understand. What is the effect of memorandum and articles? You're already very close to exam, so I may not be teaching you something new, but I'm making the thing simple for you. How the company law can be read up much faster, how you can speed up the learning. Okay, so let me stop the sharing for a moment and then we'll come back again. You have any questions till now? Any questions? No. Can you hear me properly? Okay, okay. So I was talking about the impact of memorandum and articles. Okay. So see here. You can divide that in two parts because we are talking about two documents. One is a memorandum and another is article. As far as memorandum is concerned, this is a binding company. Members and outsiders. Section 8 company, these are the same, no exemptions for the capital. Number of directors are also same. That is for a private company or a public company, no change in the number of directors. Capital requirement is also same. Or you can have it as a company limited by guarantee. Okay, so here, so as far as memorandum is concerned, this is binding the company, the members, as well as outsiders. Right? Have you heard the doctrine of constructive notice? Doctrine of constructive notice. Is there anyone for whom this is something new? Doctrine of constructive notice. Every outsider dealing with the company is deemed to be aware of the contents of memorandum. It is presumed that he has seen the memorandum, he knows the contents of memorandum of association. That is called a doctrine of constructive notice. Constructive means presumed and notice means information. So every outsider dealing with the company is deemed to be aware of the contents of memorandum and articles of association. As far as the articles are concerned, this binds company and members. Binds company and members. Outsiders are not bound by articles of association. As far as articles are concerned, there is another concept called as doctrine of indoor management. There is doctrine of indoor management. So outsiders can presume that whatever is written in the articles of association that has been complied with by the company. But as far as memorandum is concerned, he is deemed to be aware of the memorandum and he should inquire whether the requirements of the memorandum are met or not. If the conditions of the memorandum are not met, better outsider does not deal with the company. The doctrine of constructive notice. This goes in favor of company. Right. So outsiders should be aware of what is contained in the memorandum and articles of association. Okay. Now I'll tell you something more. Have you noted this one? Can I clear this? I'm not able to see any response. Are you able to hear me? Okay. So then the memorandum and articles are amended. What is the impact of amendment? Just let me write. Amendment of memorandum and articles of association. What is the impact of amendment? We'll see the theory, but right now I'm explaining you what is the impact of amendment of the memorandum and articles of association. So whenever there is an amendment, again, amendment of memorandum and amendment of articles. How this will impact? As far as amendment of memorandum is concerned, this will have prospective effect only. No retrospective effect, it will have only prospective effect. So the amendment will become effective from the day it actually takes place. But as far as articles are concerned, articles are binding only company and members. It will have retrospective effect. Retrospective effect. So memorandum of the or amendment of memorandum will have prospective effect, means it is effective from the day on which amendment resolution is passed, amendment is actually done. That is called a prospective effect. Retrospective effect means it will be effective from a back date. Back date means as if these were already a part of original articles of association, because that is a contract between company and members. Outsiders are not affected because of articles. As far as the articles are concerned, for outsiders, we have doctrine of indoor management. Outsiders can presume that the conditions of articles have already been complied with. So any amendment in the articles will have effect as if amended articles were already there in the company since incorporation. So amendment of articles will have retrospective effect. Amendment of memorandum, these are having only prospective effect. Is it clear? Okay, so this is about the amendment, and now I'm going ahead with the further sharing of the document. I was there. An article. So once again, I'm here. If subsection 10, there's a subject to provision of the Act, the memorandum article shall, when registered, bind the company and members thereof the same extent as if they have been signed. So the binding effect, the previous chart I have already given you there. To whom these are binding. Then commencement of the business, this commencement of the business in relation to the company which are having share capital. Underline here, which are the companies having share capital. It doesn't talk about the private companies and public companies. It is talking about the companies having share capital. So no company which is incorporated after the amendment dated 2019 and having a share capital shall not commence any business or exercise any borrowing powers. So here, what is important is we are not talking about the private company or the public company. What we are mentioned here is a company having share capital that shall not commence any business or exercise the borrowing powers. What is the meaning of commencement of business? What is the meaning of commencement of business? Any type of business agreement is also considered as commencement of business. Buying and selling, that is another part. Receiving services, giving services, that is another part. Right. So commencement of business is entering into any type of contract or execution of the contract, that is the commencement of business. And what is not a business is allotment of share capital, allotment of debentures. That is not considered as commencement of business or exercise of borrowing power. So making issue of share capital, making issue of share capital will never come under commencement of business. So theoretically, a company can issue share capital even before commencement of business. Right? So such a because this is what the declaration is required. If the company does not do that, it cannot commence a business. So clause A says a declaration is filed by a director within a period of 180 days of the date of incorporation, then such form verified in the manner with the ROC that every subscriber to the memorandum has paid the value of shares agreed to be taken by him on the date of making the declaration. So this is he has already paid, right? And not only that, the company is also required to make allotment of the shares for which the application has been made by the promoters. So signing of the memorandum by the promoter itself is an application. They are not supposed to make a separate application. And the moment they pay, the allotment can be made. So allotment of share capital is not equal to commencement of business. Issue of debentures is not equal to commencement of business, but allotment of debentures will be. So theoretically, you can issue the debentures even before commencement of business, but before allotment, you must be authorized to commence business. So what is the declaration required to be filed? The first declaration which is required to be filed after the date of incorporation in case of companies which are having share capital, that the subscribers to the memorandum have paid the money for which they have subscribed the memorandum. And number two, a verification of the registered office, that is the evidence of the place where the registered office is situated. Okay, so other things you can read. What is important that I'll tell you. Registered office of the company. This we discuss. What is the impact? What is the meaning of registered office? Last time we discussed that. What is the meaning of registered office? The registered office is the place, or you can say company's address in the record of ROC, where all the legal communications are required to be sent. Not only ROC, but every government office, the same address will be in record, and any document or notice required to be served to the company or to any of its officers, if it is sent to the company's registered office or if it is left therein, it is deemed to have been delivered to the company or that office. That is the importance of registered office. So, okay, so I'll write something for you on the board. So right now, sharing the topic, or stopping the sharing, and now focus on the board. Can you see the board clearly? So, registered office. What is the meaning of registered office? Company's address registered with ROC for all official communication, right? That is one part. Number two, various records are required to be maintained Various records are required to be maintained at the registered office. Over a period of time, either you have already read, or we will see what are the records required to be kept at the registered office. In addition to that, this registered office in the memorandum we have already talked about that the state of the registered office determines the jurisdiction of the tribunal under which bench of the tribunal the registered office of the company is situated. That also determines jurisdiction of the ROC. Jurisdiction of ROC, tribunal, court, all these are decided on the basis of address of registered office. Right? Then, any notice to company or officer shall be sent to the registered office. And once it is sent to the registered office, it is deemed to have been received by all. Right? This is the importance of registered office. When the company should have a registered office, prima facie company should have registered office immediately on incorporation. Theoretically, it says that you can have the registered office within 30 days after incorporation, but practically, you have to have registered office before you file the documents for incorporation of the company, along with the evidence that you have a right to establish registered office there. It may be your own property, it may be a rented property, whatever be the situation, you have to give the evidences for that. That is called verification. Now, if you want to shift the registered office, how will you do that? Shifting of registered office. So you can put here shifting of registered office. Now, when you want to shift the registered office, this can be in two ways: in the same estate or another estate. What is the difference? If you shift to another estate, memorandum is required to be amended. And if it is in the same estate, memorandum does not require any amendment. Okay, so here I'll write, when you shift to another state, this requires amendment of memorandum of association. As long as you are doing it in the same state, the registered office clause of the memorandum, which contains only name of the state in which the registered office is situated, that does not require any. Okay, now within the same state, again I will divide that in two parts. Same city and another city. Okay, then this another city can also be divided in two parts. Same ROC and another ROC. Now, within the same state, another ROC that is possible only in two states. Maharashtra and Tamil Nadu. Other than these two states, either there is one ROC in the state or one ROC is for multiple states. Right. So this is how the amendment of the registered office clause is going to affect you. If it is in the same state and it is in the same city, what is required is only a board resolution, nothing else. Only a board resolution and the filing of the address of the new registered office with the ROC. No further approval is required. If it is another city but the same ROC, this will require a board resolution followed by a special resolution and then filing of documents with the ROC. Okay. If it is this one, then it will require a board resolution, then a special resolution, then getting approval of the regional director, and then filing the document with the ROC. You will have to have approval of the regional director. If it is another state, law says it requires approval of central government. So what you will have to do in this case, you will pass a board resolution followed by a special resolution followed by central government, of course central government power delegated to the regional director, and then file relevant document with the ROC. So this is how the registered office can be shifted. Same state, another ROC. This is here in the same state. I mean, memorandum is required to be amended only when it is another state. In the same state, ROC will, or change of ROC doesn't require amendment in the memorandum. Generally, every document is required to be filed with the ROC within 30 days. In general time for filing the document with the ROC is 30 days. You see, the question here is, the question was also Prafulla. No, somebody else here. So when the central government approval is required, only when there is an amendment in the memorandum, in the registered office clause of the memorandum. So it is, if you are shifting the registered office from one state to another, it will require central government approval. So as I said, powers have actually been delegated to the regional director. You don't have to apply to the central government, or you don't have to go to the MCA for getting the approval. Right. So for the namesake, it is written central government with powers delegated to ROC or regional director. Here it is already mentioned regional director. Form numbers are already there in the material. So here we are referring the law. Right. And if I go into the details of everything for in the entire period allotted to me, I'll cover up only one chapter. I'm giving you the minor and finer points. Okay. So that you understand and get a clarity. If you have a very specific question about law, that we can discuss here, not the procedural part. Okay, so this I am leaving as it is, and again coming back to the sharing part. So back here, registered office of the company. A company shall within 30 days of the date of incorporation. So I said, in general, the time required for filing the document with the ROC shall be 30 days. The company shall furnish to the registrar verification of the registered office. Forget this, not required. Now, which are the places where registered office of the company should be mentioned? Everywhere where from company carries on business, every legal document issued by the company, every communication issued by the company should have the registered office address. Why it should have? Because the jurisdiction of the court is determined on the basis of which, and jurisdiction of the tribunal, jurisdiction of ROC. If somebody with whom you are dealing, if he happens to be outside your state and he wants to check anything about your company, where you should approach. So he should approach the ROC under whose jurisdiction the company's registered office is situated. So unless you mention the registered office, he will never know in which state he should be approaching for getting the information about the company. So registered office is required to be mentioned at every place where from company carries on business, on every legal document, every official communication issued by the company. That is also required even on the company's registered company share certificate. every contract, agreement, etc. Okay. So in the procedure, when you write, whenever registered office is shifted, you will have to make amendment at all these places where the registered office name is address is required to be given. Subsection 5. This is except on the authority of a special resolution passed by the company, the registered office of the company shall not be changed. In case of an existing company outside the local limits of any city, what is mentioned here? Same city only board resolution. So that is not even given here. So if you are shifting within the same city, only board can take a decision and no other further approval section is required. But if you are shifting to another city and it is the same ROC, then what you need a special resolution. But before passing a special resolution, board approval is required. So that's why I mentioned board resolution followed by a special resolution. And whenever you pass a special resolution, you are required to file a copy of the certified special resolution, certified copy of the special resolution with ROC within 30 days. That is the sequence I have mentioned here. So if you're shifting the outside the local limits, you have to get the special resolution. In case of another company, again the same. Only by passing a special resolution, you can shift the registered office outside the local limits, but it has to be within the jurisdiction of same ROC. Now, see the provision, what is mentioned here. Provided no company shall change the place of registered office from the jurisdiction of one ROC to another unless the RD approval has been obtained. So here we have already mentioned the approval of the regional director. Approval of the regional director. Okay. Now, when you get the approval of regional director, that is also required to be filed with the ROC once again. So that is about the shifting of registered office. Then here it comes the alteration of memorandum. Now I'll tell you one by one the alteration of memorandum. This is already done. Can I clear this one? Or somebody wants to take a note of this? See, you're always sitting with a mobile phone. So wherever required, you can just click the photo and do that. By chance, if there is a delay in taking the copy, immediately click a photo. Otherwise, the video will be uploaded later on YouTube. Therefrom, you can take it. Okay. Then, when I say alteration of memorandum, amendment of memorandum. First is amendment of the name. I'm stopping sharing. You can see that in broader way. आ गया? Addition or removal of the words limited, private limited, that is not considered as amendment of the name clause of memorandum. So for that, you don't have to do anything in specific. So when a private limited company is converted into public company, you have to complete the procedure for alteration of the company, for conversion of company from one to another. Okay. So addition or removal of the word limited, private, limited. Anushka, you can see or you cannot see. I'm not, message is not clear. Anushka. Okay, okay, good. Okay. Hmm. So here, addition or removal of the word limited or private limited, that does not amount to amendment of name. Kiran, check your net connection. Okay. Now, what is amendment? Anything other than addition or removal of the name private or limited or the private limited, that is an amendment. And this amendment, this can be in two ways. On central government direction and by company on its own. Amendment in the name can be done by the company on its own, and this can be done on the direction being given by the central government. So when the direction is given by the government, company's name is undesirable. When the company's name is undesirable, central government can issue a direction to the company to amend the name or to change the name. Right? There are different situations. We'll refer later on the law. If this is the situation, company can change the name by passing an ordinary resolution. Company can change the name by passing an ordinary resolution. But when company wants to do it on its own, this will require a special resolution. There is a difference. So where name is amended by the company on directions given by the central government or by the ROC, then for doing that an ordinary resolution is required. But when that is done by the company on its own, an ordinary resolution will be sufficient. Okay. So anytime you go to the general meeting for passing an ordinary resolution or a special resolution, you will have to have a board resolution passed. So in all these situations, what will happen? You will have first of all a board resolution followed by ordinary resolution or a special resolution, and then filing with ROC, and then amendment in memorandum, and not only memorandum, everywhere that the name of company appears. Everywhere you will have to make these amendments. So this is how the name of the name of company can be changed, right? So even before passing this board resolution, you have to ensure that the new name is available for registration. Okay, so even before this, you can write this: confirm new name. Confirm new name. And then only pass a board resolution. Otherwise, you pass a resolution later on ROC says this name is not available, the whole exercise will become a waste. So therefore, whenever there is any amendment in the name, whatever be the reason, the first step will always be to get the approval of the ROC that the new name is available for registration. Then pass a board resolution, then pass a special resolution, either ordinary or special, then go to ROC and file that. Now you have to write two resolutions. Homework, right? It's a homework for you. Draft a resolution passed by the board of directors for amendment in the company's name. Noted the homework. Draft a resolution. Okay, I'll write it on the chat. I'll write it on the chat for all. Draft a board resolution for change of name of company. I've especially mentioned a board resolution. I didn't say only resolution because this resolution will be subject to further approval of members in the general meeting and confirmation by the ROC. So write it that way, right? Resolved that in accordance with the provisions of so and so of the Companies Act and subject to further approval of members in the general meeting by way of ordinary resolution or a special resolution and further registration with the ROC, etc., etc. So you have to write a resolution properly. And once you have written the resolution about by passed by the board, then write another one, draft general meeting resolution for change of name of company. This is your another homework. In last session also I gave homework to all and only 2 people submitted their homework. Only 2 people. Out of thousands of people who have seen the lecture, if only 2 people submit the homework, what kind of results you are expecting in your life? I am putting in my all the knowledge to educate you. I am giving you time, but you people are not submitting even homework. I don't know whether it's not submitting or not even doing that. Write on the chat how many you did homework. Non-submission is okay, but how many did you did that? Yes. Only one message. Okay. Submission is okay. Submission is not a problem. Problem is whether you are doing or not doing. If you are not doing here, you will not do in the exam also. And every 6 months exams are there. So are you preparing for this exam or you are preparing for the next exam? So if you make excuses, you don't submit the homework, you don't do the homework, take my words, you are not preparing for this exam, you are preparing for next and next and next and next exam. And these are the people who will always be suffering whole life and they will never have good results. Recording is available on YouTube. You can go and see there. See, when somebody puts in his heart and soul into teaching you, what he is expecting from you? Only a response, right? And you miss even that also. Who's going to be the loser? How to submit? You can send it on the email, you can send me on phone. I can see that. Okay. So if you're serious, learn it properly. Otherwise, our association will end on 9th when my time is up. If you want to be serious, learn it properly. If not, life is yours, decision is yours, and wherever you are standing in your life today, it is already a result of the practice of the habits that you have. And now onwards, also whatever you have in your life, that will also be the result of your habits. So change your habits. Okay. I'll guide you sometime later on about how to make the habits and how to break the habits. So did not attend the session, that is okay, but that is already available on YouTube. You can go there, you can see what I gave as a homework. Okay. And I'm surprised that lots of people don't join the lectures also on time. Anyway, it's your choice. I must complete my task. I've taken certain responsibility to educate you, and I will do that. Now, this is about the name. The next one is about the registered office that I have already spoken. Then comes amendment in the object. Amendment of the object clause is not something great, that is only a special resolution. Liability clause cannot be changed. The capital can be altered, and for alteration of capital, we have very, very specific section. So capital can be altered by increasing the authorized capital number of shares. You can consolidate the shares, you can subdivide the shares. A number of ways capital clause can be altered. So the main thing about the memorandum alteration are two things only. Number one, the name. Number two, registered office. Other things, those are certainly a part of the subject, but those will cover up only as and when the time comes. What if the members not in a position to contribute to share capital at the time of incorporation? Can they reduce the proposed capital after incorporation before applying for the dividend? No. Whatever is commitment done. So at the time of incorporation, commit only for one share. Who wants you to commit for 1,000 shares? Commit for one share. One share is having the face value of rupee 10 generally. Later on, you can have more share. That is a different part. Okay, so initially we don't have to commit for 1 lakh rupees or 5 lakh rupees. You have to commit for the minimum number of shares, and you have to have minimum paid up capital that you can do later on as well. That cannot be less than that. Company can change, or you didn't. Company can change its name on its own whenever it wants to have it, any kind of change. And for that, you need to get the approval of ROC. First of all, get the approval of ROC that the proposed name is available. Then pass a board resolution, then pass a special resolution, then apply to the ROC for amendment for registration of the new name. And when it is registered, there will be amendment in the certificate of incorporation, and then incorporate amendment at all the places. Change of name. You didn't tell the chart. Which chart you want? Okay. So now further proceeding ahead, going back to the sharing. So alteration. So this I now come to subsection 2. This is any change in the name of company shall be subject to the provisions of section 2 and 3 of section 4. Section 4 is there in the about the memorandum. So how that name can be changed, that we have already discussed. Now, further, no such approval will be necessary where only change the name of company, the deletion therefrom or addition there to the word private. So private to public or public to private, that is not considered as amendment of memorandum. That is a change of a status of the company. The change of a status of the company will automatically have an effect on the name of company. So you don't have to follow the procedure for change of name. You have to follow the procedure for conversion of company from private to public or public to private. Any change in name of company made under subsection 2, the registrar shall enter the new name. So this is all procedural. What the law is, that I have already discussed with you. Okay. Going ahead further. Alteration of articles. The meaning of alteration of articles. Any of the conditions incorporated in the articles that can be amended, but except in case of section 8 company. In case of section company, if you want to alter the conditions in the articles of association, you need to have the prior approval of the central government, and otherwise an amendment can be done by passing a special resolution, except where it is a conversion of public company into private company. So I'll draw a small chart for you for amendment of articles. So amendment of, let me see for a while. amendment of articles. And this is in two parts. Section 8 company, and we have other companies. So there is a Section 8 company. Amendment of articles requires prior approval of central government. Can you see that now? So whenever you want to amend the articles of association of a Section 8 company, that requires the prior approval of central government. Okay. And in other companies, articles can be amended by passing a special resolution. And then if it is having effect of converting public company into private company, it requires confirmation by central government. Refer Section 8. When you apply for a license under Section 8, it is given on certain conditions incorporated in the memorandum and articles. And if you amend the articles, you cannot unless you get the prior approval from ROC or other central government. So the license is issued by the regional director. So that permission will also be granted by the regional director. So first you have to get the approval, and then only you can pass a resolution for amendment of articles. In case of other companies, you pass a special resolution, articles get amended. And if it is having the effect of converting a public company to private company, then amendment will have effect only once it is confirmed by ROC. So here you need to get the approval before passing the resolution. Here you need to go for the approval after passing the resolution. That is the difference. Aarti, any other question? No? Okay. So can I go ahead? So again, we go back to the sharing part. So alteration of articles, I have already told you, and the effect of our alteration of articles. See the provision number 1. Provided further that any alteration having the effect of conversion of public company to private company shall not be valid unless it is approved by an order of the central government. This is mentioned here. Second provision is not relevant for you. All that is you will forget. Now, section 15 not to be done, you will omit. Rectification of is important. What is the difference between rectification of name and change of name? Earlier I gave about the change of name. Now I'll elaborate a little more about the change of name. So here the title is rectification. Rectification means some error is already there. So to rectify that error, there is a change in name. And there can be a change without a rectification also. Okay. Again, I'll draw another chart for you. So here comes name. In name, you can do it this way. Rectification and change. Why rectification required? There is some mistake. And this mistake is either at the time of incorporation or this is done later on. The name is undesirable. Name is same or similar. Name is same or similar to any other company or a trademark. And if you want to change, this is a voluntary activity. Voluntarily, company can change the name at any time. It is changing the business or for some other purpose it wants to change the name, the change is possible, that is voluntary. In this case, when the name is same or similar, or this is equal to or similar to trademark of another one. In this case, ROC issues direction, in this central government issues the direction. Central government approval, how to take formal application should go. How to write procedure of conversion private to public company. You want to convert? First of all, a decision is to be taken in the meeting of the board of directors. Then you conduct a special general meeting. And for conducting the special general meeting or rather extraordinary general meeting, you get the notice approved by the board. Circulate notice, pass the resolution the general meeting, file copy of the special resolution with ROC, and also make an application for registration for amendment in the certificate of incorporation. Okay, Megla, you want to have any question? I have raised the hand here. Any question you have? You can check. You can type on the chat box. Okay. So here, I said rectification. It means there is some error in the error is in the name of either company has been registered with an undesirable name or the name is identical or very closely similar to the name of an existing company, or the name is somewhat similar or closely resembling to the registered trademark of another company. So in case of trademark being there, the trademark owner can make a complaint. He can go to the central government and then require the company to amend the name. And for that, a long time is given. That is 3 years time is given. Otherwise, only 3 months time is given. Okay. So once we, I'm going back to the provisions, so there the things will become more clearer. Okay. So whenever this direction is given, you require an ordinary resolution. Ordinary resolution will always start from board resolution, then followed by ordinary resolution, then filing with ROC. Okay. And when a company wants to do that voluntarily on its own basis, always starting from board resolution, going to special resolution and filing with ROC. And then giving impact at all the places wherever name of the company is mentioned. See, when you have gone through certain provisions, then writing procedure becomes something very, very normal process. You can always write the procedure on your own. Once you understand the procedures, provisions, that is more important. Again. So section 16 says, if through inadvertence or otherwise a company on its first registration or its registration in new name is registered by, which in the opinion of the central government is identical or too nearly resembles the name by which company in existence has been previously registered, whether under this act or under previous law, it may direct the company to change the name, and the company shall change the name of the new name within a period of 3 months from the date of issue of such a direction after adopting an ordinary resolution. So this procedure I have already given you, which is coming from section 16, subsection 1, clause number A. Then this is about the trademark. So somebody is having a registered trademark, right? Now say for example that washing powder ghadi. Okay. So now that washing powder, that is a trademark which is already registered in the name of somebody else. And tomorrow you want to register a company starting with the name the ghadi Washing Powder Private Limited. So that person will certainly have an objection. Okay. So this is clause number B is meant for that. So on an application by a registered proprietor of a trademark, that the name is identical with a too nearly resembles to the trademark of the proprietor under the Trademarks Act, made to the central government within 3 years of incorporation or registration of change. He can make an application to the government in 3 years. Government will take its own time to take a decision, and then it gives a direction, and company must comply with the direction within a period of 6 months with that. So 3 years time is for going to the government. How much time government is going to take a decision on that, that is not mentioned. But when thereafter, if the government decides that the company should amend the name, company will give a direction, and company should comply with the direction within a period of 6 months. Then these are all subsection 2 and 3. So these are not going to discuss. 17, forget, not required. Conversion of companies by already registered, this is also not required. Subsidiary company not to hold share. This is an important section which you have to understand carefully. In case of subsidiary, the holding company, who is holding shares in whom? Subsidiary is holding shares in the holding company, or holding shares in the subsidiary company? Which company holds the shares where? So in case of holding and subsidiary company, who is holding shares where? More than 50% of the capital held by one company in another, and the shareholder is called as holding and is called a subsidiary. There are some questions coming just in the chair. I'm not able to speak here. I'm stopping this thing, and once again we'll come back here. So subsidiary is a holding in a holding company. Holding company holds in subsidiary company. Okay. Okay. Holding company holds the shares in subsidiary. Okay. Good. So subsidiary company is the master company and a holding company is the member of subsidiary company. But it is referred as a master. Okay. So holding company is a member of subsidiary company and this holds or controls more than 50% share capital of a subsidiary company. Either it is holding or control. And this is more. Exactly 50%, no relation of holding subsidiary. One share more and a holding subsidiary relationship gets created. Okay. So when one company holds or controls more than 50% share capital of another company, then the first company is referred as holding and other company is called as subsidiary company. So when a holding company is the member of subsidiary company, how can subsidiary be the member of holding company? Okay, so let me understand that. Or rather, I'll explain it to you. So let us put a title here. Shareholding between holding and subsidiary company. Holding company in subsidiary and subsidiary company in a holding. This is always allowed. As far as subsidiary company in holding is concerned, this we can divide in two parts. Subsidiary company shareholding in the holding company since prior to becoming subsidiary and after becoming subsidiary. Since prior to becoming subsidiary, continue, but no voting rights. On those shares, there will not be any further voting right. There will not be any further allotment of shares, no right shares, no bonus shares. No voting right. No right shares, no bonus shares. After becoming subsidiary, only as representative of another person. So after becoming subsidiary, the subsidiary company cannot hold shares in the holding company except as a representative of another company. Is this chart clear or you have any question? Is it noted? Have you noted this chart? So now back to sharing. Now we are on section 19. This is no company shall either by itself or through the holding nominee hold any shares in the holding company, and no holding company shall allot or transfer to the shares of the subsidiary, and such allotment or transfer of shares of a company to subsidiary shall be void. This is here. No right shares, no bonus shares. Subsidiary cannot make any allotment to the holding, right? Because if it is already having prior to that, it can continue, but no voting rights, provided that nothing shall apply to where a subsidiary company holds shares as the legal representative of a deceased legal representative. Where the subsidiary company holds shares as a trustee, the trustee is also a representative. I did not mention legal representative, I mentioned representative. The trustee is also a representative. Now, further it says where the subsidiary is a shareholder even before becoming subsidiary, which is mentioned here. Since prior to becoming subsidiary, they can continue to hold those shares. Okay. So this is section 19. The whole summary is on the board, so you can continue to have this, look at this, and refer section 19. Section 20, there is nothing to do. Section 21 also nothing to do. Section 22 also there is nothing to do. So this is actually the end of the first part, which we were supposed to do in the last one. And right now, I'll take a break for 5 minutes. And in the meantime, I'm just stopping the sharing so you can have a look at the board thoroughly. And I'm putting my mic also on mute. You can certainly leave your message on the chat. I'm able to read. So friends, now I'm back. Any questions you have? So more than 50% share of the company is called, yes, more than 50% holding company. No, it's not more than 51%. Very good. Lots of communication. So the last question which I have, this says under section 14 to amend the articles for converting public company to private company requires central government approval. Now, does it require the central government approval for converting private to public too? No. Converting of a private company to public company doesn't require any approval of the central government, but converting a public company to private company required. Now, okay, let me give you the rationale why it is required. In case of public company, you have a right to issue the shares to public. And quite possible the shares have already been issued, those are already listed, and by chance, if you pass a resolution for converting into private, it is a clear violation of the provision. So the government will ensure that there are no public deposits, there is no public shareholding, and no public interest is going to be affected by converting itself into a private company. That's why it is approval. Nothing else. That is the only idea for getting the approval. But when you go from public to private, in a private company, entire investment is your own. In that case, public interest is not involved. So you can convert yourself into public without the central government approval, but converting from public to private requires central government approval. Any further questions? One, how to know if the section speaks of board resolution or a shareholder approval if simply mentions ordinary resolution? Okay. Now, this is a very, very simple idea that whenever you need to pass a resolution in the general meeting, you need to conduct a general meeting. For conducting the general meeting, there must be board approval. In the board approval, you pass two resolutions. One is for that the company conducted the general meeting, another is for approving the approving the notice. And in that situation, you need to have the board approval first, right? So where it says only a board approval, then it means a board resolution. Where it says general meeting resolution, it means ordinary resolution, but preceded by a board resolution. And when it says special resolution, then special resolution is also preceded by an by board resolution. Just say the subsidiary company holding shares in the holding company, will they get the dividend if declared by holding company? Yes, it will be given, but the law says the amount of the dividend will be kept in abeyance. It will not be given, it will be kept pending with the holding company. And when the shares are transferred by the subsidiary company to another person, dividend will be transferred to that person. You see, right shares not given, bonus shares not given, but dividend cannot be stopped. Voting rights, that is not available. Let me draw another chart for you. That what will happen if a subsidiary is holding shares in the holding company since prior to becoming subsidiary. But this is something interesting area. You see, wherever there is something interesting, I'll discuss for a longer period of time. But if pure reading, you can also read. So there will not spend time. So one chart is already here. So let me draw another chart for you. Shareholding of a subsidiary company. In a holding company, this has to be beneficial holding. So this can be in the own name or in the agent's name. Before becoming and after becoming. Before becoming, shareholding continues. No voting, dividend kept in abeyance. After becoming, no allotment by the holding company in the name of subsidiary, therefore no right, no bonus. Fresh allotment in the name of subsidiary company already prohibited, but in relation to the existing shareholding, there will be no further right issue, no further bonus issue to the subsidiary. Is this clear? Any further question you have? Otherwise, we go to the new chapter, the share capital. Okay, so presume that there is nothing, and I'm moving to the next part. Chapter 3, this is Chapter 3 of the Companies Act, Prospectus and Allotment of Securities. Section 20. 23 is saying how many ways the share capital can be offered for subscription. Title given is public offer and private placement. The title should have been different, but anyway, so section 23. Here you can write section 23 and title you can write issue of share capital. The difference is here in case of public company, in case of private company, public company can make a public issue, and this public issue may be IPO, may be FPO, initial public offer, further public offer. It can make a right issue, it can make a bonus issue, it can make private placement. In case of a private company, first one is not allowed, second is allowed, third is allowed, fourth is allowed. So this again I'll make the screen little bigger so that you can copy. So issue of capital. Section 23. How many ways a company can issue share capital? So this is saying public company can issue capital by way of public issue. Public issue may be first public issue, that is initial public offer. It can be further public issue, that is the next public offer. Then it can make a right issue, it can make bonus issue, it can do the private placement. As far as a private company is concerned, it cannot make any public offer or public issue of share capital. It can make private placement. It can issue right shares to the existing shareholders. It can make bonus shares to the existing holders. All that is allowed, but what is not allowed to the private company is public offer. Okay. So what is the difference in public offer and private placement? I'll draw a separate chart for that. Is this chart taken care of? Is noted? A little fast. When you're faster, I will also give you more things. If you're slow, your time will got in. Issue of capital. Now this issue of capital, this can be public issue or private placement. What is the main difference between the two? In case of public issue, anybody can apply. In case of private placement, offer is given to any person or persons in such a way so that only he can apply. What is the basic difference between public issue and private placement? In case of public issue, the offer is made in such a way so that anybody can apply for shares, and in case of private placement, the offer is being given in such a manner so that only the person to whom offer is given, he can make an application. That is called a private placement or a private offer. So public company can do both type of offers, but a private company cannot do public issue, it can make private placement. Okay, done this? Yes, private placement can be done to the group of people also. Up to 50 people in one financial aid you can do. Up to 50. Okay, you can add here up to 50 people in one financial year. Okay. So now come to section 23. What it says, subsection 1. This is a public company may issue a public through prospectus, then through private placement, then through a right issue or bonus issue, and a private company subsection 2 it can make by way of right issue or bonus issue, or it can make private placement. So what is not allowed to a private company? A public issue cannot be made by a private company. Private offer it can always make. Now the section 23 is saying power of SEBI to regulate issue and transfer of shares. Now this is saying that except to the extent it is already governed. I'll answer your question just. Said is under section 24 that to the extent provisions are covered in the Companies Act, those are applicable. In addition to that, in companies issue of share, transfer of shares and payment of dividend will also be regulated by SEBI. So that is in addition to the provisions under the Companies Act. Right. So others say the provisions contained in this chapter, chapter 4, section 127. 127 is relating to failure to pay dividend. So that is penalties for not making the payment of dividend. So that is applicable. In addition to that, something more can be done by SEBI. Insofar as it relates to the issue and transfer of shares and payment of dividend by listed companies or those companies which in listed on the recognized exchange except as provided in this act. Except whatever is applicable here, that will remain applicable. In addition to that, be administered by SEBI and the regulations made by it. So in those companies, in the case of listed companies and the proposed companies which are proposing to get the securities listed, in addition to the provisions of the Companies Act, they will also be governed by SEBI or SEBI Act and SEBI guidelines. So SEBI guidelines are certainly a part of your syllabus. You must be studying those in some other paper. Now, document containing the offer of securities deemed a prospectus. So, what is called a prospectus? What is a deemed a prospectus? You have to understand the difference. What is called a prospectus? What is prospectus? So, the list of all the sections. Going to section 2. For the definition of the term prospectus. So this list is of all the sections. This is a part of the same file, the Companies Act, which I was proposed to share with you. And all the definitions are always given alphabetically. So if you have to find a definition, don't bother. Just go alphabetically as if you are referring a dictionary. And here we have the term prospectus defined in the section 2, subsection 7T. Can you read it here? So this says prospectus means any document either described or issued as a prospectus. What is described, that is certainly a prospectus, but there may be a document which is not referred as a prospectus, but if it is fulfilling the condition, that will be called as a prospectus. So it says it includes a red herring prospectus referred in section 32 or shelf prospectus under section 31 or any notice or circular or advertisement or any other document inviting from the public for the subscription or purchase of securities of a body corporate. So prospectus is what? Prospectus, this is only in case of public issue. Let me explain the concept of prospectus. Okay, so this is only in case of public issue. If there is no public issue, prospectus is not required. So this public issue is only for public companies. Private company cannot make public issue. Okay, now this document described some document already described as a prospectus. This is a prospectus certainly, but not described but having effect of inviting public for subscribing shares or debentures. What does it mean? As per general understanding, that may not be a prospectus, but it is written or drafted in such a way so that it is having the effect of inviting the public for subscribing the shares or debentures, that will also be called as a prospectus. So called means that should fulfill the requirement of the act and includes. What is included therein? That includes a shelf prospectus, that includes a red herring prospectus, those are also referred as prospectus. That includes red herring prospectus as well as shelf prospectus. So those we will discuss later on in today's chapter if the time permits. Okay. So now we are going back to the sharing part. So here, document containing offer to the securities for sale to the deemed prospectus. So what is a deemed prospectus? Now, before I explain you what is mentioned here in offer containing offer for sale, the difference between issue and offer for sale. Can you tell me what is public issue and what is offer for sale? Friends, tell me quickly. Public issues are offered to the public. Okay. What is offer for sale? By existing shareholders. Public issue, this is a company. Offer for sale, this is by existing member. Now, this existing member can again do that a private deal, or he can also make a public offer. Right? So initially said that prospectus is a document issued or described by the company as a prospectus. Right? But here, who is issuing the document? If it is offer for sale, who will issue the document? Not the company, but the person. Who is that person? He is an existing member. He is issuing the document. Right? Who will get the money on sale of shares? Not the company. It is the person who is selling the shares. He is going to get the money. Right? But the document issued by that person for selling the shares, that is called as a deemed prospectus. Deemed means that will also be treated as a prospectus. So all the requirements in relation to prospectus must be satisfied even when it is an offer for sale. If it is being issued by the company, certainly prospectus is there, all the requirements must be satisfied. But even when it is not issued by the company, it is being issued by somebody else for selling the shares, still the requirements of the prospectus must be satisfied. Okay, so now section 25, what it says. So when a company agrees to allot securities of a company with a view or for all or any of the securities being offered to sale to the public, you see, is allotting it the shares to somebody, and that person to whom allotment is made, he will be selling the shares to the public. Any document by which offer to the public is made shall for all purposes be deemed to be a prospectus issued by the company. Now this you have to understand carefully. They said if company makes an allotment with understanding that the shares will be offered. Now this is valid if the allotment or the offer for sale is made within a specified time. Even if it is not within specified time, still all the requirements are the same. The difference is that if the company is making the allotment to somebody with the object of those shares being sold to public within a specified time, then it is deemed to be a prospectus issued by the company itself. And if the shares are sold by the person later on, that will be referred as an offer for sale by that person. In that case, everything will be on that person. Right? So whenever whosoever is issuing a document, whether it is being issued by the company or it is issued by somebody else, since it is at par with the prospectus, all the contents are required to be same and all the responsibilities and liabilities are bound to be same. So whether it is a case of misstatement or it is a case of omission, everything will remain same. What is called a misstatement in the prospectus? Here already given liability in respect of misstatement or omission. What is misstatement? Not only wrong facts, false statement, no, that is also something more is involved. False is correct, wrong is correct, what more? Quite possible information given is correct, but that is not related to the subject. Not wrong facts only. Wrong facts are certainly wrong. You're already using the word wrong and false. So when you are using the word wrong and false, that is in any case misstatement. But when information given is correct, but it is not in relation to the company, not in relation to the situation, then it will be referred as a misstatement. That is also misstatement. Right? Now, say in the current situation, what is happening? Medicines for corona. Right? Lots of medicines are being issued for the treatment of corona without a complete research on that. So that is becoming a misstatement. If it is supported with the evidence that yes, it works for this, it will not be a misstatement. But when it is not supported with the scientific evidences, this becomes a misstatement. Okay. So misstatement is not only false and wrong. This is something more, even if it is correct, but it is not supported with the evidence, it is not in relation to what is being said, then that is also referred as a misstatement. Even omission is also misstatement. Something very important on which you can take a decision, if that is missing, that is also called as omission. So that is also a misstatement. And the purpose of prospectus. If you understand the prospectus, the word prospectus, you will understand the word misstatement correctly. Let me give you the reason. What is the purpose of prospectus? Why the prospectus is required to be issued? This is educating an investor to take informed decision. Have all the information required to take a decision about investment in the company. And in that, either you omit some good information or you give information which is not accurate, or which is false, or which is wrong, or you give information which is not relevant, all those amount to misstatement, right? So what we misstatement? So I'll put a title misstatement, then write 3-4 words therein. Take a note of that. Misstatement. As you said, false, wrong information, that is the misstatement. Any important omission, that is also a misstatement. Information given in some other context, that is a misstatement, right? Now, say for example, some of hospitals are required to give a report to the government about the COVID statement, COVID position daily. Now, today the hospital is giving a report that yesterday 200 patients were discharged from the hospital. Yesterday, 200 patients were discharged from the hospital, but they did not know that they were COVID patient or not. The 200 discharge information is correct, but that is not in relation to COVID. That also becomes a misstatement. This is that information given is not the same in the same context. So information being given is not wrong, it is not false, but it is also not what is required. So that is also called a misstatement. So that leads to taking wrong decisions. So objective of prospectus is to educate the prospective investor to take the correct and informed decision. And if it is not helping to take the right decision, that this is said to be a document containing misstatement. So whether misstatement is there in the prospectus or it is there in the deemed prospectus, liabilities and responsibilities remain same. Subsection 2 says, when it is presumed that the company has made the allotment with the object of being sold to the public. Subsection 1, the company makes an allotment of the shares with the object of being sold. So when it is presumed that the offer is, when the company has made the allotment of the shares with the object of being sold to the public. So if the shares are offered for sale to the public within 6 months after allotment, and by the time the shares are offered to the public, the company has not received the full money for which the allotment was made, it is presumed that company has made the allotment of shares to one person or group of persons with the object of being sold to another people or sold to public. So matters to be stated in the prospectus. This will not go into the details because this is as per SEBI regulation. Simply you can say. This is important. So this is one example that you have to understand subsection 5. The left margin, it is showing some comments. So this kind of value additions I'm going to do in the entire act. And that's why I'm taking a little time to do the value addition before I share it with all of you. So subsection 5 says a statement of expert can also be included in the prospectus. So who is an expert in relation to prospectus? In relation to prospectus, an expert means having good knowledge, that is one part. And number two, his opinion may affect decision of investor. He will be referred as an expert. And not having any financial interest in a company. So before a statement of an expert can be added in the prospectus, what is required, that you can see it on the board. We will come back again. So expert need not be a qualified CA or CS or CW. Anybody can be an expert. Suppose this is an expert, this is a public issue coming out with a company which is into manufacture of cement. So some technical person making some comments, that will be referred as an expert. Right. So expert need not be professionally qualified. What is important is he is having a good knowledge, and more important is his opinion is going to make a difference on the decision of investment by the investor. So any Tom, Dick, and Harry won't be because of degree, he cannot be treated as an expert. And he should not be having any financial interest in the company, only then his statement can be included in the prospectus. So any statement of an expert can be included in a prospectus only with his written consent. No shareholding in the company, no remuneration from the company. Otherwise, he, because of vested interest, he can always make good comments about the company. The person who is expert in a specific field, he can make any comment about the company, and a comment may be positive. It may change the decision of investor in favor of company, and if that is to be incorporated in the prospectus, then his written consent is required. So without written consent of that person, nothing can be added in the prospectus. And once it is added in the prospectus, he will have a responsibility for any wrong statement given. He will also have civil liabilities. He will also have criminal liabilities for making a wrong statement in the prospectus. If shares are held by the family member, then he is not interested. Family members may hold, but he should not be holding any financial interest directly, because what statement you make in the prospectus? If you are issuing a prospectus, you are including the statement about any expert. You'll talk about expert only, not about his family members. So his family members may have interest, but that person should not be having any interest. So these are lacunas of law. Right? So all the shares are held by a family member, but this person is then absolutely independent, and he is making all the statement about the company. Right? So there are penalties for inducement. So he will not come directly as an expert, but he will be responsible for inducing other persons to make investment by giving the wrong information. So liabilities will be there. So this is about the expert. So in the subsection, prospectus issued under subsection 1 shall not include a statement purporting to be made by expert unless the expert is a person who is not and has not been engaged or interested in the formation or promotion or management of the company, and has given his written consent to the issue of prospectus, and has not withdrawn the consent before delivery to the ROC. So that's why his written consent is required to be used. So any statement by an expert can be included in the prospectus only with the written consent. And when prospectus is filed for registration, this written consent given by expert should also be filed with the ROC for the purpose of registration. So that is that this person has given a state permission for including his statement in the prospectus. Now, number 8, no prospectus shall be valid if more than 90 days after the date on which a copy thereof is delivered to the registrar under subsection 4. A prospectus valid for a certain number of days only, and 90 days is not the time. 90 days is issued to the public. So when the prospectus is not issued to the public. So first of all, you have to understand what is the meaning of issued to the public. The moment prospectus is approved by the board, signed by the board for being issued to the public, and it is filed with the ROC, it is deemed to have been issued to the public. So this subsection 8 literally becomes immaterial. So the moment it is signed by the board and it is filed with the ROC, it is deemed to have been issued to the public. Variation of terms in the contracts. Now this title you have to understand what is the meaning. In every prospectus, you have to define the purpose for which public issue is being made, and in relation to that purpose, how many contracts companies have. Company may be having contract for supply of machinery, supply of raw material, for supply of the finished goods, etc., etc. And if the company proposes to make any amendment in the contracts which are already referred in the prospectus, then company will have to get the approval of members. We're not talking about in this section about amendment in the terms and rights of the members. This is about the contracts, right? So these contracts may be procurement, maybe manufacturing, maybe sale, maybe some other thing, whatever be the contract, because in the prospectus you give a reference of number of contracts. And if any variation is required to be done, then be done only with the approval of members by way of a special resolution in the general meeting. So here I'm writing a statement. So before I write, you can take section 27, and here we have already seen. So provided that details have been prescribed on the notice in respect of such a resolution to shareholder shall also be published in the newspaper. So section 27, I'll write on the board. You can take the note of that. So section 27. What is the way? If it is withdrawn before, after registration. So after registration, but before the closure of the public issue, then you have to give that information to public. And if you withdraw that consent after the allotment, then nothing can be done. Now, section 27 says, now the background of section 27. Reference of number of contracts is required to be given in the prospectus. If terms and conditions of any such contract are required to be amended, then get approval of members by special resolution. Deepika, can you see that? Or you cannot? Some network issue can be there. Some other, can anybody see that, or everybody is having a problem seeing the board? Okay, okay. So Deepika may be having some network issues. So whereas the number of contracts, that is not 1 or 2 or 4 and 5. Various contracts, whatever is having a relation with the subject for which the public issue is being made. Say for example, company is into manufacture. So manufacture of item number XYZ. Now, for that, it will have contract for supply of raw material, supply of equipments, then supply of finished goods. This is I'm referring number of contracts, right? So by chance, if you are having any problem, communication issue at this point of time, you can certainly see the video again on YouTube. Network creates a problem. So if there is any internet speed related issue, because of that, it may not be clear. But this is not a problem with everyone. Lots of people can see it clearly. Are you seeing it clearly? Some people can see, some people cannot see. So where is the issue? Issue is in the internet speed which you are having now. First video is certainly available on YouTube. Check it. Around 1,000 people have already seen that. Okay. So network issues do arise. I work on very high internet speed, so there cannot be any problem from my end. Okay, so these problems are there, but these are network problems. ICSI students, that you can see that, right? You want to see right now? I can just a minute. I'll show you that. Just wait for a while. I'll show you. Okay, now I'll show you that channel. On YouTube, I say YouTube channel for students. There you can go and see the number of videos. Here is my old video. Okay, so this you can see there. So this is the YouTube ICSI students channel. It is already there. Got it? Any more question? So Institute has created a wonderful facility for you. If you are attending live, you can interact with me. Otherwise, just watch videos on YouTube. Videos not clear. Okay, so let's continue further. So going ahead. So offer for sale part, we did that, and moving further. public offer of securities to be in demat form, nothing much is to be understood there. So wherever details are not required, I'm not going to wait. Okay. So if any explanation is required, I'll explain. Advertisement of prospectus not required. Now, shelf of prospectus, this is something that you have to understand. What is the meaning of shelf of prospectus? So earlier we talked about the validity period of a prospectus. So that is valid for a maximum period of 90 days. But when a shelf of prospectus is there, this is having validity of 12 months. It is having validity of 1 year. So shelf of prospectus can be issued only by specified companies. And as of now, you can say these are banking companies and financial institutions which can issue the shelf of prospectus. Right? So those were not very clear as far as the English language is concerned. There is a difference between shelf and shelf. So we are not talking about self prospectus. We are talking about shelf prospectus. So shelf prospectus can be issued only by banks and financial institutions. Only by banks and financial institutions this document can be issued, and this is valid for 12 months. In general, one prospectus is for one public issue only, but a shelf prospectus is valid for any number of issues which can be made during the validity period. Okay. So shelf prospectus, I want to elaborate little more. So I will first we'll read the shelf prospectus part, and then I'll explain you what is shelf prospectus exactly. So this is any class or classes of companies. So which companies can issue? I said banks and financial institutions can issue that. As the SEBI may provide for regulation, may file a shelf prospectus with the ROC at the stage of first offer securities included therein, which shall include not exceeding 1 year. So that is the period of 12 months. By period of validity, such prospectus shall commence from the date of opening of the first offer. So validity is 12 months instead of normal validity period of prospectus. And a company filing a shelf prospectus shall be required to file information of the memorandum containing all material changes that is related to the capital, financial position, etc. whenever it wants to issue a new capital, new issue of capital. So let me explain. Once again, I'll close the sharing and then come back again. Or section 12 is talking about the red herring prospectus, that also I'll explain. I'm going to explain two things now. One is shelf prospectus, another is a red herring prospectus. Okay, so take note. So here, shelf prospectus. This is only banks and financial institutions, and this is valid for 1 year since number 3, any number of public issues So generally one prospectus for one public issue, but for the purpose of shelf prospectus, any number of public issues can be made during validity of the shelf prospectus. And for a new public issue, a statement of changes in a financial position shall be filed. Only a statement. So this statement plus shelf prospectus already filed with ROC, these together will become a prospectus for every public. So this is called a shelf prospectus. All the requirements of the prospectus have to be fulfilled in relation to shelf prospectus also. Only difference is that number one, this can be only by the banks and financial institution. Number two, validity period is 12 months. Number three, any number of public issues. And number four is this. So these are differences as compared to any other prospectus issued by any other company. Now coming to the next topic, that is red herring prospectus. So red herring prospectus. This is prospectus issued for book building process. So what is called book building? I'm using the word BB. Book building process is a process of public bidding for deciding number of shares to be allotted for raising predetermined amount. Book building process. This is the process for, or are the process of public bidding for determining the number of shares for raising a specified predetermined amount. So say for example, amount is rupees 100 crores. Now, how many shares should be allotted for raising 100 crores? That will depend upon the price at which shares are being offered for subscription. So, price is determined on the basis of bidding, right? Number of shares, that depends on price, right? So suppose share is being offered for rupees 100 rupee per share. So 1 crore share is good enough. If share is being given for 200 rupees, then 50 lakh shares are good enough. Then depending upon number on the price, the number of shares will vary. So it depends on price. Bidding. This is within price band given by company. So who's bidding? Bidding is by public. Where from they can bid? They have to do the bidding within the price range given by the company. So that is called as price band. Actually, that is a price range, but that is called as price band. So company is giving a price band. Say company has given a price band of rupees 175 to 190. Then bidding has to be within this range only. Any bid below 175 is rejected, any bid above 190 will be rejected, and after the bidding is complete, company will decide a one price at which the entire issue can be sold, and quite possible company determines that 180 is the final price. So allotment of the shares will be at 180 for everyone. So book building is a process for determining the price and number of shares for raising a specific amount. Here we already have a specific amount of 100 crores, and how many shares have to be allotted, that will depend upon the price, and price is to be decided by bidding. Bidding has to be within the price band. Price band is this. Is this concept clear? Red herring prospectus are not explained. Is this point clear? How this is done, this is what I'm explaining. Okay. Once again, I will explain red herring prospectus. I will come little later. Right now, let me explain what is big book building process. Suppose a company wants to raise rupees 100 crores. Okay. For raising 100 crores, it should decide the price. At what price it will allot the shares? Price of shares. That depends on bidding. Okay. Then bidding. This is within the price band given by company. Okay, so price band this is minimum and maximum price for bidding. Final price, this is decided by company. And allotment is at same price to everyone. Okay. Now understand this, that suppose company wants to raise rupees 100 crores. Company is inviting the bid from public, for which it is giving the price band. Once again, we take the same example, say 150 to 160. This is the price range given by company. And you can bid. Your bid should not be less than 150 and it should not be more than 160. Then after receiving the number of bids, company decides that final price Final price is rupees 155. So what will happen? The bids which are below 155, those will be rejected. And the bids, if those are above 160, those will also be rejected. So only those bids which are between 155 and 160, those are eligible for being considered for allotment, and everybody will get allotment at rupees 155 only. Right? Now, as far as the price band is concerned, that depends upon number of market factors. There's no one formula that on which basis this price is going to be decided by the company. Okay, so I said no one formula, that depends upon number of factors. In which industry, how old it is, how established the industry is, how reputed are the promoters, what is the market demand, etc., etc. Number of reasons, factors are taken into account for determining this price band. So once the price is determined, I said final price is decided 155. So when you have that 155, only then you will know exact number of shares to be allotted for collection of 100 crores. Right? Now I will define exactly what is called book building process. Maybe may be covered in some other chapter for you, but here I'm just giving you an idea. So what is called book building process? Book building process, this is process of public bidding for determining number of shares and price thereof for collecting predetermined amount. Your question says, what if the final price is more than the bid price? So that differential cannot be paid, that bid will be rejected. That's why the people bid for the higher amount, not the lower amount. Where the company is good and the person is interested, he will never quote for the lowest price. He will always quote for the highest price. Any bid below the final price will be rejected. Okay. So this is called book building process. Now, in relation to the book building process, you will understand what is the red herring prospectus. Okay, this I'm removing. Yes, whenever there is a book building process, that will be applicable for all the shares. Now, red herring prospectus. What is red herring prospectus? This is the document required to be issued for inviting public bids in book building process. This is the document required to be issued for inviting public bids for in the book building process. This is a complete prospectus except price and number of shares. So what is required to be there in the prospectus? This is all the things are required to be in this document also. So this is a complete prospectus, but except price and number of shares. After bidding, when price and number is determined, prospectus shall be filed. For registration. So when it is issued only for inviting the bids, it is referred as a red herring prospectus, and when price is finalized and number of securities are finalized, then prospectus should be filed for registration. So registration will have, when the prospectus is filed for registration, it will have price, it will have number of shares also. So when a document is issued to the public for inviting the bids, it is referred as a red herring prospectus. And when the bidding is complete, price is there, number of shares are there, then it becomes a prospectus. So that is the difference between prospectus and the red herring prospectus. I said prima facie it is as good as the prospectus. It is having complete information, but only two things are missing there from number of shares and the price. Have you noted all this? Any questions on this? But not much of the time is left. Okay, so now bidding is applicable to no debenture is the borrowing, there cannot be any bidding. Debenture is the borrowing amount. There cannot be debentures. Okay. So this is about the red herring prospectus. Now see here, this says a company proposing to make an offer of securities may issue a red herring prospectus prior to issue of prospectus. What we said? Prospectus is after determining the price and the number of shares. So that red herring prospectus is prior to prospectus. A company proposing to issue a red herring prospectus under subsection 1 shall file it with the ROC at least 3 days prior to the opening of subscription list. So subscription list will come, or rather you can say that this prospectus, after bidding when the price is determined, prospectus shall be filed for registration. This is that one. So prospectus should be filed for at least 3 days in advance. Red herring prospectus shall carry same obligation as they are applicable to prospectus. See here. This is document required to be issued and this is complete prospectus. So everything about that I have already mentioned here in section 33, not required, that you can read. Then liabilities in relation to prospectus. What are the liabilities? So liabilities in relation to the misstatement in the prospectus. There are civil liabilities and as well as there are criminal liabilities. So civil liabilities are always limited only to the extent of compensating the person to the extent of any loss, and criminal liabilities are in the form of penalties and punishment. Right. So let me draw a small chart for you, but before that we will refer section 34. So here what is said in section 34, that where a prospectus issued, circulated and distributed under this chapter includes any statement which is untrue or misleading in the form of context in which it is included, or where inclusion or omission of any part, every person who authorizes the issue of the prospectus shall be punishable, liable under section 447. So 447 is the penalty for fraud and misrepresentation. So right now we are on page number 60, and I'll take you to section 447, and section 447 I have included here. This is section 447. Refer this. What it says. What is the penalty? Without prejudice to any liability, including repayment of any debt under this act or under other law for the time being in force, any person who is found to be guilty of the fraud involving any amount of at least 10 lakhs rupees or 1% of the turnover of the company, whichever is lower, shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 10 years, and shall also be liable to fine which shall not be less than the amount involved in the fraud, but which may extend to 3 times of the amount involved in the fraud. So if where there is a misstatement in the prospectus, what is the liability? Now let's get back to page number 60. So those who are not very frequent with the word, you can understand that also. So here you can type page number 60 and directly you reach there and then close it. So here. So there also we can prepare a chart and I'll give you a chart. So this you have seen what is the criminal liability under section 447. So the and civil liability. Civil liability is only to the extent of repayment of the money and compensating for the loss. Who are responsible? The directors as well as company both are responsible, and the persons who are responsible for issuing the prospectus. And the liability is the repayment of the money and compensating the person for the loss. So there I am drawing a chart, and that will be last one for today. Okay. So once again I am stopping the sharing and preparing the last chart. So the next topic will be in continuation of this one. And I don't know the next topic. I think that is about the deposits and charges. Deposits and charges are there, plus general meetings portion is also there. You can read that. And the next lecture, I have already mentioned that the next lecture will be on 2nd. Right? Tomorrow there will be no lecture. Then 4th, then 7th, then 9th. These are the dates on which I will be having the next lecture. So here it is. Liabilities. For misstatement in prospectus. So liabilities are in 2 parts. Civil and criminal. Civil liability, this is company, directors, expert. This is mainly directors. Mainly, there can be other people also responsible. As far as civil liability is concerned, this is number 1. This is compensation for loss. Criminal liability, this comes under section 447, and this is fine up to 3 times and imprisonment up to 10 years. These are the liabilities in relation to misstatement in the prospectus. There are civil liabilities as well as there are criminal liabilities. And people will not have a liability if they can prove whatever they have said in the prospectus that is correct, or they did not give their permission for including their name in the prospectus. Their name is included without their consent, or they've given the consent but it was withdrawn before the registration of the prospectus. And if it is withdrawn after the registration and before allotment, then a public notice is required to be given. And once it is after the allotment, then nothing can be done, then liabilities are always there. So if they can prove that nothing is wrong, it is only the wrong understanding, then there are no liabilities. But if it is proved that it is something seriously wrong, then these penalties are liable. So this is all that I can do today. Rest all we will be doing in the next lecture. In the meantime, you can give me your feedback. And as I told you, you can certainly share your numbers with me. And in a day or two, I will share the complete Companies Act. You can share your feedback with me about the lecture today. And if you want something more, that also you can write to me so that I can cover up next time. I'm writing my email ID also. If you remember my name, my email ID is automatically remembered. My email ID is tayalsir@gmail.com. So if you remember my name, everything is clear. My phone number is already given, my email ID is already given, and you can your request if you want to a specific topic to be covered, that also I can take care of. You want anything specific in the next lecture on second? Yes, private placement don't have to do much. Appointment of director, that will come. Rule number 9 I will take care of. Deposits I'm going to cover in the next lecture. Deposits and charges, yes. ICDR cannot be done. Okay, so depending upon the time available, I'll complete maximum information for you. Okay, I'm trying to do the maximum possible. So see you soon in the next lecture on second. Till then, have a very good time. Study a lot, do homework, and I love you all. Thank you very much. I don't think auditors I will do. Accounts, audit, no. I said most important chapters I will do. General management part, very important. Board provisions, very important. I'll do in detail. Meetings, yes, I'll cover up. Comparison of important provisions, important topics. Whatever I said important, yes, I'll cover up those things. So now any further messaging you can send to me directly. My number is already with you. Okay, because this will go on YouTube, so lots of people don't require this much information on YouTube. So be in touch. Thank you very much. See you there.